welcome to this online lunchtime seminar of the DST NRF SARChI Research Chair for Mineral Law in Africa. I'm Anri Heyns. I am the Chair for Mineral Law in Africa. And with me today are speakers from various African countries.
We have Dr. Anri Heyns. She is the organizer of this lunchtime seminar, which is about local content and development in the mining sectors in Africa. Dr. Heyns is a postdoctoral fellow and a legal consultant, and her thesis was on post-development theory and local content. And her interest at the moment is in legal design thinking and solutions. And she is joined by an alumni of the chair, Dr. Korir Sing'Oei, who is now the Principal Secretary of Foreign Affairs for Kenya. And his thesis was also on local development and benefit sharing, and he focused specifically on the counties in Kenya. And then we have a special visitor to UCT, Dr. Yvonne Idun, and she is truly the kind of specialist that one needs in the mining sector in Africa, a master of all trades. Her thesis was in waste management, and she has been a consultant on various projects relating to poverty alleviation and refugee empowerment and rural development in Africa, in various African countries. And we're very privileged to have all three of these wonderful speakers here to talk about local development in the mining context in Africa.
Unfortunately, Professor Elizabeth Bastida from the University of Dundee will not be able to join the conversation today, but her presentation focusing on systems thinking in the natural resource context will be added at the end of the video. By way of brief introduction, I can mention that Professor Bastida has been working in the law, policy, and governance space of natural resources for several decades, and she has recently authored a book, The Law and Governance of Mining and Minerals, A Global Perspective, which I've just finished reading, and it is a very compelling read. We are very pleased that she was willing to participate in the video of this particular event.
From my side as well, I just want to thank everybody for, well, firstly for my co-speakers, for Dr. Sing'Oei and Dr. Idun, for being willing to join us today at the seminar. We are going to be talking about local content laws in resource-rich African countries, and specifically about how can we design these laws so that we can design a better future for Africa. So I also want to thank all the other attendees today, and I really hope we can have a conversation at the end of the session to see what are the things that we can do going forward when we look at local content laws on our continent. So what I will be talking about as part of our conversation on the design of local content laws, I'm specifically looking at how we find this notion of community in the South African Mining Charter. And I want to consider legal design thinking as a tool for doing so. So I want to introduce this notion of legal design thinking, you might have heard of this, as a way in which we can analyze local content laws. In my example specifically, I'm looking at the Mining Charter in South Africa. But before I talk about legal design thinking, I will just highlight some aspects about the Mining Charter, specifically how it aspires to empower mining communities in South Africa. And then once I've set out briefly what legal design thinking is about, I will return back to the Mining Charter and the provisions on community, so that we can see if legal design thinking can maybe assist us in firstly, how we interpret the Mining Charter, but secondly, going forward, how do we design similar policy instruments so that we can ensure that the benefits of mining are shared with local persons living in mining areas, but also in the countries that are affected. So obviously, when we talk about local content laws and we talk about mining in South Africa specifically, we are dealing with the notion of poverty in mining areas. And you'll see here, these are some of the ways in which mining areas in South Africa specifically are often depicted in the media and in literature. And what is important to note is when the media and literature speaks about mining areas in South Africa, it also specifically refers to the communities that live in these areas. And when we talk about communities in this context, we talk about sharing different things. We talk about sharing geographical space, sharing the effects of poverty, sharing custom, sharing land and land usage. So it's important for us to be critical about what it is when the policy says, or what we're talking about when policy says we have to do certain things to develop communities. In South Africa, we've got a legislative system in place that does promote the development of mining communities in South Africa. So we've got the Mineral and Petroleum Resources Development Act, that's the overarching legislation. And in terms of this legislation, there are basically two instruments that provide for the development of communities. On the one hand, we've got the Mining Charter. That's one of the initiatives that is set up in terms of Section 100 of the MPRDA that specifically asks that a charter must be set up to promote transformation in the mining industry. And this charter has got two provisions that is specifically aimed at communities. The one deals with ownership in the mining right holder or the mining company, and the other deals with how the mining right company must promote mine community development in the area where it operates. The MPRDA also makes provision for the creation of a social labor plan, the SLP, and this must be submitted by the mining right applicant whenever it applies for the mining right. The SLP will set out the mining right applicant's plans for promoting local economic development in mining areas. But irrespective of this legislative intervention that has been with us for a couple of years now, it cannot be said that the legislation is successful if we view the legislation's purpose as sharing the benefits of mining with previously disadvantaged persons and specifically with communities affected by mining. So let's see what the legislation says about the community, and specifically let's look at the Mining Charter. So if we look at the definition of community in terms of the MPRDA, it speaks of a group of Black or historically disadvantaged persons with an interest in rights, in land, and they exercise this communally or in terms of agreement, custom, or law. This seems to refer to an indigenous or a traditional community. The Mining Charter seemingly takes on this definition whenever it speaks of host community by saying that a community in a municipality adjacent to a mining area will be regarded as a host community. That's the one definition or view of community in the Mining Charter. The other one is where the Mining Charter speaks of a mine community. Now, this is a much broader definition. Here, this refers to communities where mining takes place and labor sending areas and adjacent communities within local municipalities. So you will note that those two definitions are not exactly the same, and the importance of this distinction will become clear in a moment. If we look at all the other legislation, the transformative legislation in South Africa that will impact communities in mining areas, we can see that usually four types of commonalities are acknowledged by our law. That is of sharing custom, family, and land, sharing the effects of mining, sharing space, and then also a community as sharing poverty. So what does the Mining Charter say about the empowerment of communities? Maybe just two steps back before I look at the Mining Charter's provisions specifically. The Mining Charter in South Africa sets out to promote broad-based Black economic empowerment in South Africa. But broad-based Black economic empowerment is regulated in our country in terms of Broad-Based Black Economic Empowerment Act, which applies to all sectors, and each sector can have a different sectoral code that will apply. In general, BBBE provides for direct empowerment, human development, and indirect empowerment. And as you will see here, this can include the transfer of ownership in the company to Black persons and also the promotion of social development. The Mining Charter has got a very broad description of what mine community development should entail. Here you can see it speaks of meaningfully contributing to its mine community development in line with the social license to operate. So just by reading this provision, it's not exactly sure what a mine community can ask for when it sort of asserts its rights in terms of the Mining Charter. The mine community development element that forms part of the Mining Charter also speaks of the mining company having to align its development plans with the social labor plan. But just by looking at the instrument itself, it's not all that clear what exactly a mine community can ask for when it stands in front of a mining company based on the Mining Charter. The situation is slightly different when we look at host communities. So you'll recall that I mentioned that host communities refers to communities in mining areas and often includes traditional communities, communities that share custom, land, and culture. And in terms of the mining charter, a mining company has to provide 5% shareholding in the mining company to host communities to be held in a community trust, and the profits or the revenue generated through the shareholding must then be used for host community development. This program, however, should be distinguished from the mine community development program. So clearly, we've got a situation where the mining charter distinguishes between two types of communities, on paper at least. I know in reality it can overlap. And to me, it seems as if on the one hand, this host community or the traditional community is being preserved by the mining charter, since it can be argued that this community is centered on some kind of an essence, on identity. It shares land and custom and culture. But this other type of community, which shares poverty and the effects of mining, is not necessarily recognized, but the motivation behind the provisions of the mining charter is to transform these communities. And in my PhD research, I called this phenomenon the politics of development. And I argued that the politics of development is why we find that provincial mining charter are not successful in achieving its objective. And the reason why I'm saying this is in this way, the mining charter is probably inadvertently setting up these two communities against one another. It's setting up misrecognition as an injustice against maldistribution as an injustice by acknowledging the host community as a legal subject that can hold shares, but not acknowledging the mine community in a similar way. Here, there's this open-ended provision or hope for mine community development, but it's not quite clear what the mining charter asks of the mining community in this regard specifically. And the reason why this is important is if we look at the mining charter from a developmental perspective, where the underlying notion is to promote development through mining, holding shares or property is a very important aspect of the promotion of development. So if you tell one group of persons in a mining area, you get to hold shares in a mining company, and the other group of persons are only entitled to open-ended mining development initiatives, I do think this can promote inequality and conflict in mining areas. So that's the problem state. If we now think about how we can address the legislation or the problems in the legislation currently, I want us to look at this notion of legal design thinking. So what is design thinking? There are different definitions of design thinking, but the Hasso-Plattner Institute describes it in terms of a 5-stage process. You take a problem, then you emphasize with the target audience to understand the problem that they're experiencing. You use the information that you gain to define the problem properly from their perspective. You ideate, in other words, you create different ideas as to how the problem can be solved. And then an important aspect is you create different prototypes. Otherwise, there's not just one solution. There are different solutions that you can ultimately test before you implement it as a final solution. So if you talk about legal design thinking, it's about integrating these design thinking principles with a lawyer's legal expertise, And then it's also an interdisciplinary approach that has got the human being at the center of its focus. So instead, for lawyers that want to apply legal design thinking, the focus is not necessarily on the law, but the focus is rather on the human that's being affected by the law. So you have to know what the problem is that has to be addressed. You have to know who the persons are that are being affected, and you have to have a holistic view. The purpose is to solve the problem of the target audience. So you have to know who the target audience is. And it has been applied in contract drafting, dispute adjudication, and the reform of the legal system. If we think about new designs in the legal context, you could talk about a contract template or information guide or a process to deal with a legal problem. But in our context specifically, the design of new legislation or policy is then very relevant. What are the principles of legal design thinking? Basically, it's creating human and centered design solutions, addressing the needs of real people, looking at the problem and the solution from their perspective. You have to collaborate with other professionals. Lawyers do not have design skills. It's not part of our syllabus at university. So there is a need to engage with other professionals for us to find solutions, real world solutions. An important aspect of design thinking, and I'm anticipating this is the one that lawyers will be most uncomfortable with, is exploring and testing the solutions that we create. And another one that we might be uncomfortable with is embracing technology. So you might recall a couple of slides back, I spoke about the 5 stages of design thinking, and one of these stages is the prototype stage. So usually if we think about prototypes, we think about when cars are designed or other technological developments are taking place. But in the US, there have been projects that were successfully implemented where they used the prototyping phase on policy. In other words, before the policy is implemented as law, they use a type of sandbox or experimental time frame within which the policy is implemented, feedback is obtained, and this is a way of testing whether this intervention is actually working. And this way you can actually preempt deficiency. And also, legal design thinking can help providing access to justice. You can prevent the issue from arising or prevent harm from being caused, or at least limit the damage that is caused whenever a dispute takes place. And how does this happen? It's by designing information on rights and responsibilities in a better way. And you can also promote collaboration in this way. So if we take what we know about legal design thinking and what I've mentioned now is very superficial, it's only sort of a few highlights of what legal design thinking is about. But if we take it, bring it back to our problem with the mining charter, and just to refresh your mind, for me at least, the mining charter distinguishes between different types of communities without necessarily acknowledging the result or the consequences of making that distinction. Legal design thinking is human-centered, and the question you have to ask is, who's the target audience? So the solution that you're creating cannot be open-ended. It shouldn't just be about the law that you're creating. You have to ask who the target audience is. So here's the target audience of. And because of the incorporation of the rhetoric and development rhetoric and the way in which Section 100 speaks of sharing the benefits of mining with historically disadvantaged persons, we want to believe that the target audience of the mining charter will be the mining communities and the beneficiaries of empowerment. But if we look at the structure of the mining charter and what it is, and the fact, so for those of you who do not know, the mining charter sets up the elements that a mining company must comply with in order to maintain its mining license, mining right. And attached to it, there's a scorecard. And a mining company will actually be assessed on each element to determine the score that it will achieve in, for instance, promoting lifelong development or human resources development. So just by looking at the design of the mining charter, and maybe the notion of broad-based economic empowerment, yes, the broad-based nature focuses on communities, but businesses still decide how these initiatives are implemented. For me, it gestures to the fact that maybe the target audience of the mining charter is not mining communities and the beneficiaries, but maybe it's the mining companies that have to implement these provisions. So what does that mean? It doesn't necessarily mean that mining companies find it easy to implement or interpret the charter either, but just if we view the mining charter from this angle, maybe we can think a bit differently about the challenges that we are experiencing, and specifically the question about whether the benefits of mining are shared sufficiently. So just a few concluding remarks then. I don't think legal design thinking is a silver bullet to issues that we have with local content laws. Legal design thinking is not going to get around the politics involved in policy creation. Specifically, I mean, the mining charter is a political instrument. There are various political interests that have to be balanced in instruments such as that. And we have to take note of the nature of BBB in their development. Despite the rhetoric changes around it, it's still a top-down initiative. You still require the mining company at the end of the day to implement many of these initiatives. So I think questions we can ask is, at what level of governance will it make sense to try and implement legal design thinking in creating policy? And also, is legal design thinking maybe just a way in which we can, civil society and academia, can disseminate information to communities and beneficiaries of instruments such as the mining charter? So I'm leaving these questions open for now, and I'm hoping after we've listened to the other speakers that we can talk a bit more about this in our discussion. And I think I am handing over the microphone to Dr. Sing'Oei now. We are looking forward to hearing what you have to say about your observations in team.
Well, thank you very much, Anri, for your very concise and thoughtful commentary on this subject. My own conversation really centers on local content from the perspective of one of the most well-known scholars in the area of design, particularly from an economic perspective. The late professor of economics, Eleanor Ostrom. I study the issue of local content as one of the tools for ensuring the devolution of benefits of resource development to communities and to subnational governments in Kenya. As we may all be aware, Kenya has a fairly small mineral development sector. It contributes about 5% to our GDP. It still has huge potential, but the core challenge revolves around how resource development can ensure equitable benefits to particularly resource host communities. Reforms in the mining sector have taken place since 2010, when Kenya promulgated a new constitution. The constitution incorporates the whole idea of benefit sharing and requires that Parliament would put in place legislation to ensure that both counties, which are subnational governments in Kenya, and communities are able to benefit from resource development. And what we have then seen since 2010 is a plethora of regulatory and legislative reforms that have tried then to ensure that this constitutional intent is advanced. Of course, the role of institutions in ensuring that mineral resource development does not yield negative externalities that is likely to trigger conflicts characterized by, in the literature as resource costs is a subject of a vast array of legal, economic, sociological, and other disciplinary focus. And what is evident from the literature is that the difference in impacts of resource development processes across countries appears to lie in the design and quality of domestic institutions and their ability to manage resource endowments transparently, apply these resources to socioeconomic developments, and to do that in an equitable fashion. And so the Mining Act in Kenya, which was enacted in 2016, has a framework for benefit sharing across the national government, the county government, and communities. There is a monetary dimension to that, and there is a quota for each of those sections of our society. So, for example, national government gets about 70%, the county governments get about 20%, and communities get 10%. So that's sort of the revenue share that rises from royalties that are paid by a mining operator. But that's sort of on the monetary side of benefits. On the non-monetary side of benefits is where the issues of local content then are sort of relevant. And in relation to local content, I think there's a range of devices of local content. ranging from, employment opportunities, service provisions by a community, social investment programs, amongst others. The Mining Act goes forward to then require that a large-scale mining operator needs to negotiate and implement what is called a community development agreement. And so what I do in my work really is to look at all these developments against the perspective of what Eleanor Ostrom formulated as design principles. And Eleanor Ostrom develops about 8 principles that she argues that these principles speak to the resiliency, the stability, and the capability of institutions to address what is otherwise known as the tragedy of commons in relation to common property. And I analogize in my writing that the tragedy of commons is sort of similar to the resource curse phenomenon, because it talks to a situation where resources are aggregated, but because of overuse, because of lack of shared rules for the management of those resources, then those resources become depleted and therefore become unavailable for the collective, for the common good, or for the community in the long term. And so Eleanor Ostrom proposes that there are 8 principles. The first principle she discusses is the issue of delimitation of boundaries and borders around the resource. And what does that mean? It means that there has to be clarity about what is the scope of the resource. Number 2, there has to be clarity around who the beneficiaries of that resource are. In other words, who has the legal mandate to access these resources. And therefore it speaks to the question of what is that community in question. The second principle is what she calls the principle of proportionality in the allocation of costs and benefits, so that in this circumstance, those groupings or entities that bear the greatest cost must be recipients also of the greatest benefits, and so that you ensure proportionality. The third principle she enunciates is the principle of democratic participation in relation to the rules governing this particular resource. Then she goes ahead to propose that there has to be mechanisms for monitoring, mechanisms for sanctioning, and she argues that those sanctions have to be graduated so that they increase in severity to the extent of violation or infraction vis-a-vis the rules. She goes ahead to speak to the need for redress mechanisms so that when there is conflict amongst within the group or within the community on the one hand, or conflicts between the community and other entities higher up in the hierarchy, then there is a mechanism that can be able to internalize that challenge. She argues for the need to, at the operational level, recognize locally formulated norms by the communities involved. And lastly, she argues for what she calls the principle of polycentricity, which is really about multi-level governance, where she proposes that there needs to be, if you're dealing with a larger system or a larger resource, there needs to be a multi-layer approach to resolving issues around common property. And so what I do then is to look at the regulatory regime relating to community development agreements and how they align with these principles. And so in relation to community development agreements, for example, the law, the Mining Act provides that 1% of the net revenues of a mining operator will be allocated towards what is called community development. That community, then that 1%, are governed by this agreement. And the idea then is that a community development agreement has a governance structure to govern the use of these resources. That governance structure comprises of 14 members who are appointed at the national level, not necessarily at the subnational level. They're appointed by the Minister of Mining, they're gazetted. And it's only 6 of the 14 who actually come from the community level, the host community level, which means then that in terms of power asymmetries, it is likely for the 6 to be overwhelmed by the other 8 who are still appointees of the national, government. The regulations governing the community development agreements then provides that the committee will have like 3 subcommittees, including one committee that focuses on project development, like identifying in consultation with the community involved, what are these projects that can address the needs of the community. The presumption is that would be done in a participatory fashion. And then there is a committee that then monitors implementation, which is sort of the monitoring committee. And there is a committee on conflict resolution or redress. And so in assessing the extent to which this regulatory framework aligns with the principles set down by Eleanor Ostrom, I do find that there is a measure of alignment, but nevertheless, one can point at a great deal of dissonance between the principles on the one hand, and the regulatory regime on the other. And what is then required is to actually probably engage in a quantitative study where one can be able to look at the situation on the ground to determine in practical terms how these committees are actually functioning. And so in one particular county where this is taking place, the county of Kwale, we have a large operator that is involved in the extraction of rare earth minerals, a company known as Best Titanium, that is already implementing quite a number of community development agreements. And it'd actually be quite interesting to then look at it from the perspective of what is a practice vis-a-vis what is provided in the law. And so part of my study and part of my focus is to look at the questions around implementation and whether we have within the current regulatory regime enough incentives to be able to ensure faithful implementation of these rules, because absent that faithful implementation of these rules, we will still default to old ways of doing things, which have precipitated crisis within the mining sector. I want to stop there and to thank you.
Thank you very much, Korir. I'm now going to ask Dr. Idun to please do her presentation. Thank you very much.
Hello, everyone. I'm very delighted to provide you perspectives from Botswana's diamond industry. I'll give a brief generic overview, then we'll look at some salient features of the diamond mining industry in Botswana and issues on ownership. Then we'll go specifically into the legislation which governs the diamond mining industry in Botswana. After that, we'll also look at the successes. Generally, what we will see is that we have a lot of success stories to share, but that's not to say that we have 100% sort of utopia kind of scenario. There are still 1 or 2 pitfalls in legislative enforcement and that sort of thing. But overall, what we'll see is that when we look at the scenario in Africa surrounding the mining sector, Botswana can be probably cited as one of the countries which has made some great improvements or has some good trends which are worthy of emulation. Other countries could learn a thing or two as far as the local content laws are concerned. Okay, when we look at issues like the mining and exploration duties things concerning royalties and imposition and collection of taxes, tax incentives for mining investors and projects, the provisions from the law relating to attracting investment for mining and so on. There's a great emphasis on what could really benefit the local communities. And I have lived in Botswana in the past. I've not been to any of the mining towns, so Rapa, Joanin, Letlakane, and the rest. But I know for a fact that the laws take into consideration the interests of the locals, and that is very good. Sometimes the foreign companies or the foreigners used to look at those things as, they protect the locals too much. But what sense would it make if you look at a country like mine, where I'm coming from in Ghana? We have a lot of gold and diamonds and so on from our mining towns in Takwa, in Pristia and the rest, but there's so much poverty. I mean, if you look at our laws, they look so good theoretically, but when it comes to enforcing these theoretical principles in reality, it's really sad what happens. For example, the way mining waste is dumped. Sometimes it affects even the drinking water of the local populace. If you look at the poverty, that is rife in some of these mining communities, it's really sad. And if you dare to point these things out, some time ago, I did a consultancy for the UN University, and some NGOs came out and spoke very openly. By the following morning, we got some people from the ministries to come and tell us that everything that happens in Ghana is perfect. But I don't think so. It's happening in reality. And we have Chinese companies at the moment, we have MTNs. There's nothing wrong with attracting foreign investment, as Botswana has done. But you see that in the case of Botswana, I like what they do. It's not even just putting things theoretically. They make sure that as far, as possible, the local, what we're talking about, the local content or the interest of the local populace are really promoted. So having given that generic background, when we talk of sustainable development, we're talking of ownership. And we're looking at the marginalization of rural communities, as I have said, because it doesn't even make sense to have all these rich minerals and resources in your territory. And then you have exploitation going on. And when you go into those towns, you don't even see what is happening. In Botswana, we know that I'll give you some little features. I'm sure you all know the capital is Abroni. The official languages are English and Tswana. They protect even their local language, Tswana. They use it at the national level. It's one of the, countries and official languages. They are very proud of their culture. They are very proud of what they have. And they are happy, as I say, to protect the interest of their people. The places of interest in this country include the Okavango Delta, Makolodi Nature Reserve. The Botswanas set aside about 17% of their land as nature reserves. They have a lot of minerals, but I'm focusing on the diamond sector because the diamond industry has brought in a lot of money to them, and the future, fortunately, looks bright. They have a population as of 2018 of about 25 million people. Their GDP as at 2019 in US dollars was about 44.3. The name of the currency is the Botswana Pula. As I say, we won't look too much at the other sectors. We're just going to focus on the mining industry. Okay. The mining sector in Botswana continues to be one of the most successful, as I've said. During the second quarter, for example, of 2022, mining production stood at 88.9%, showing a year-on-year growth of 3.8% from the second quarter of 2021. Things get better. One time there was a destruction, there was a fire outbreak at the largest diamond mine in Orapa. But that set things down a little. There was a little decline, but luckily things have picked up a lot. So as I said, the mining towns are in Orapa, Joaning, and Letlakane. Botswana, for As I say, mining accounts for about 60%, about 50 to 60% of the government's revenue. When it comes to the laws, before I talk about the laws, there's also one thing we need to note about Botswana. Unlike many African countries, they've had a lot of different, Botswana has enjoyed steady political stability. And that has also contributed, to the implementation of sound laws as they promised to deliver, in these laws I'm about to talk about. They have political stability, and then corruption. I'm sure there's corruption there, but when you also compare to the others in the African continent, I would say that, they've enjoyed quite a great deal of, corruption-free leadership and that sort of thing. A president comes on TV to explain where he got money to operate an ostrich farm. That's the kind of country, Botswana is. Okay, so we have the Mines and Minerals Act of 1999, Cap 66.01, that's number 17. We have the Botswana Mining Law of 2016. And even that, they are not just patting each other on the back, the lawmakers, parliamentarians, and so on. They always try to make reforms and trying to improve things as far as they can. Even this law, I know for sure, as we are talking, work is being done to make recommendations and try and improve, make amendments, for improvements and so on. We have the Mineral Rights in Tribal Territories Act. We have the Precious and Semi-Stones Act, Cap 66.03. We have the Diamond Cutting Act. The main act is the Mines and Minerals Act. These are all subsidiary legislations and so on. Over there, the mining industry, as I've said, is highly regulated, and the legal framework ensures that mining contributes to the economic growth of the country through the enactment and administrative of legislative, fiscal, and institutional policies, so as to attract foreign investors, subject to international standards, and subject especially to the interest of the local communities. Okay, so as has been noted by the Fraser Institute, they have written many things about the mining industry in Africa, as I'm sure a lot of you know. They stated in October 2016 that Botswana is pro-mining and has efficient bureaucrats, no corruption, reasonable and consistent regulations, and reasonable taxation. This country encourages and assists project development, I'm quoting. It is the jurisdiction other African countries should strive to copy. Okay, we have the National Development Plan, MDP 11. We have the, according to this plan, Botswana is focused on building a sustainable and resilient development pathway. Okay. So we'll look now at some of the laws, the salient features, because I know that we're a bit constrained with time. So we'll look at some of the salient features, as I have said. If you consider the issue of ownership of mineral resources, we have, for example, in terms of Section 13 of the Minerals and Mines Act that I just quoted, a person who desires to obtain a prospective license in mining is required to make an application to the minister by completing a set of forms as set out in the first schedule to the Mines Act. If you look at Section 14 of the Act, the minister may grant a prospective license if certain requirements are met. For example, the proposed program of prospecting operations should be adequate. They should make proper provision for environmental protection. Why are we talking of environmental protection here when we mention the issue of ownership? Remember, I gave you a scenario from my own country, Prestia and Tapa, how people were struggling, apart from having to drink contaminated water from rivers. In a mining town, you don't even have pipe-borne water. Children are sick, you don't have good hospitals. You don't have good tarred roads. You don't have hospitals, schools and those things. If you are in those mining towns and you get sick, you have to travel about 8 to 10 hours before you get to the main government hospital in Accra. Those kinds of things are what Section 14 here is trying to avoid. And an example here is the environmental protection thing. One time people were drinking water, which had been contaminated with fecal waste, which had been generated from people who were employees of the multinational agency there, the company there, a Canadian company, their fecal waste was not being treated well. So it used to end up in the rivers that the local people were fetching water from to cook and use to clean and so on. And people were getting sick. Pregnant mothers were dying. Babies were being born sick and that sort of thing. So, and then the environment was being contaminated as well. So these are the sort of things that this kind of law seeks to abolish. When you look at Articles 13 and 14. And the minister, there are so many provisions here, but time will not permit me. If you have time, I know we said we will come up with a publication from this, and I will go deeper. I have a lot of material here. I'm just picking up. For example, the minister shall grant a mining license if he is further satisfied that the proposed program of mining operations ensure the most efficient and beneficial use of mineral resources in the proposed mining area. You see, they're talking of the proposed mining area here. Our emphasis here is on the local content, the interest of the local populace. It's not and just taking everything to Abroni or Serowe or the big towns. So even if you go to Orapa, Joanin, Letlakani, and the rest, it's not only a segregated portion of the populace who are enjoying the benefits of these mineral or diamond explorations. Everybody, as far as possible, is also enjoying a bit. In terms of Section 23 of the Minerals Act, a prospective license or any interest therein may be transferred to any other person, provided the minister is notified at least 30 days before the intended transfer. So the minister is also very much involved, and they are also a group of community leaders, what they call the other stakeholders, and they are all also involved in, their interests are taken into consideration when they are considering these applications to grant some of these concessions, whether to local people or to foreigners or whatever it is. Okay, so we also have a situation where we've seen that, Botswana has a lot of, these national parks. I mean, in East and Southern Africa, these countries in the continent are blessed. We have a lot of national parks for safari and tourism and so on. We have Chobe National Park, we have Gemsop National Park, we have Makadikadi Pans National Park, so many of them, which are pursuant to Section 5 of the Wildlife Conservation and National Parks Act. They have been declared a national park for propagating, protecting, and preserving wild animal life, vegetation, geological, and scientific interest, and so on, for the benefit and advantage and enjoyment of the inhabitants of Botswana. So over here, if you discover some minerals and so on, you can't just go there and say that we are going to, the government should set tourism aside, we are going to destroy these parks. Already it's a bit of a, because of the Kalahari, it's a bit of a desert country. So these are the things that, they also preserve, these game reserves. You can't just go and collapse them because you want to go and dig into the mines and collect money and go away. The local inhabitants also enjoy these things. And it's very interesting to see that they have been declared, in policy that these things should be also preserved for the interest of the locals. Section 12 of the Mines Act provides that the holder of a mineral concession should, in conduct of its operations under such a concession, purchase, construct, and install facilities, give preference to the maximum extent possible with the safety, efficacy, and economy to the materials and products made in Botswana, and the persons whose service agencies located in Botswana and owned by Botswana citizens or bodies corporate established under the Companies Act, Cap 42.01. Okay, so there are a lot of requirements. Impact of specially protected communities on mining projects, community development agreement for mining projects, good and bad examples of community relations, and so on. If you look into all these laws, you see that all they seek to do, in fact, what you are coming to do, let it not cause climate change and so on. So all these things seek to promote the interest of the Botswana, that's the local Botswana citizens. If you look also at the Diamond Cutting Act and the Precious and Semi-Precious Stones Act, this basically is their focus Okay, so at this point, we'll now look at some commendable initiatives on ownership under these laws. It is noteworthy that this company, that's the Botswana, 3 minutes left, okay. That's the DBS, the main foreign company, has a partnership with the government of Botswana, and they have set up a special fund for development. And they give, for example, in the year 2000, they gave over $500,000 US for rural development, as well as caring for disabled children, HIV/AIDS. The Orapa mines and Letlakane mines have been said to employ over 3,000 Botswana in their diamond industry. The Botswana also maintains a 100-bed hospital. They've built excellent primary schools for employees' children and the Orapa Game Park. They have also promoted a lot of water conservation, waste management initiatives, all trying to conform to what the stipulations of these laws are. So yeah, I think these are things that we could also learn from other African countries. We know that on the other hand, some of the pitfalls, I know I have very little time. There are many people from the San population, that's the Basawa. They were evicted from their land some time back and left homeless by the government because the government granted vast diamond and uranium concessions to the Botswana company in the year 2000. And as a result of this, there were a lot of health clinics and water pumps and food supplies which were cut off. Those are the kind of things that they are trying to reform their laws to avoid. So on the whole, I would say that, yes, the situation is not 100% perfection scenario. We can't have utopia when we are talking of analyzing some of these laws. But I think to a very large extent, Botswana is a success story. And I like their emphasis on promoting the interests of their local populace. You know, as I said, charity begins at home. People think that maybe they are a bit too protectionist, but I think that yes, they can't just sell their diamonds and let people come and enjoy when their local populace can't even get something as basic as decent water to drink. So on this note, thank you very much.
Thank you so much, Yvonne and Korir and Anri for introducing us to this topic. It was lovely listening to this. And in the back of my mind, I have this ideal, this wish of creating a manifesto for mining in Africa. And I hope that some of the conversation that we are going to have now will feed into that conversation.
Thank you very much. Just listening to you made me miss my days in Kenyatta School of Law, where I used to be head of department. Kenya is a very beautiful country, yes, as you rightly said. I remember horticultural and forestry and the rest are those areas which were very largely exploited and so on. Would you say that on the whole, Kenya has been successful in its laws, you know, promulgating and enforcing its mining laws?
Thank you, Dr. Yvonne. Thanks also for your very elaborate presentation. I think in relation to whether or not Kenya has been successful, especially in relation to its extractive sector, I think the jury is still out on that question. And that's part of what I was pointing out in relation to just one discrete element, the community development agreements, which seeks to create a framework for the, you know, for addressing the needs of resource host communities. And in relation just to that matter, I think the view that I have is that we need to, you know, that the law is, I think it's very progressive. The regulations are progressive. The nub might be around implementation. And so we need to be quite deliberate in monitoring and tracking the manner in which both the mining operators are implementing the regulations, but also the manner in which national government is disbursing revenues allotted to counties and to communities arising from royalty payments. And so there's still, it's too early still for us to say whether or not Kenya has been successful on this question, and therefore quite a bit of monitoring is required. Thank you very much.
Korir, I think Yvonne, sort of the questions you asked meant that you partially answered my question, but you ended your presentation off with saying, okay, so obviously the principles show that there's misalignment and you need to see what's happening on the ground. And you spoke about incentives. You said maybe the current legislation doesn't even have enough incentives. And I think after listening to Yvonne as well, and me thinking about the design of laws and things like that, it seems to me as if yes, because your answer to Yvonne now was the laws are progressive and maybe implementation is the problem. But I'm wondering if implementation is the problem, should we then maybe look at the design of the laws again? So it goes in the circle argumentation, but I'm just wondering, and I think that's the thing that I'm thinking about the whole time when you think about design is, yes, we can have perfectly designed laws, but implementation remains an issue. Why? But will implementation remain an issue because maybe the laws aren't perfectly designed, because they forget who the target audience is at the end of the day? So yeah, that's just my 2 cents.
Thank you, Anri. I think you're completely on point. I think sometimes it's a chicken and egg kind of situation that we are dealing with. And in my thesis itself, I actually I contrast, for example, the local content regime within the Mining Act itself versus the local content regime within the oil and gas law, which actually is very, very extensive in terms of being prescriptive. But secondly, what the oil and gas local content provisions do is to give a fair measure of deference to county governments at what is called the county assembly level to formulate further rules, particularly touching on the structure and the mechanism for the governance of what is called a trust, that is the holding entity for the benefits allotted by the law and by the constitution to the communities and to the county. The Mining Act, on the other hand, seems to distrust the idea of devolution, of that decision-making and consultative process. And therefore, the National Assembly itself is the one that rolls out a fairly extensive regime of regulations, and therefore there's a bit of a tension there between the philosophy governing the mining legislation, the mining regulations on the one hand, versus the oil and gas regulations. And it harks back then to the question of, what is really the guiding principle within the state in terms of, can we trust communities to propose better design? Can we trust subnational governments in relation even to what the Constitution has already, devolved to them? Or is it always going to be that national government is going to handhold communities even in relation to an area where they need to exercise the right to self-determination? And so I think it's both. I think it's both a design problem, but it's also largely an implementation question and a political will question. Thank you very much.
Thank you, all three speakers. I think these were really excellent and for me, very thought-provoking and very informative. So thank you for building our capacity. I really, really appreciate it. Firstly, and that applies to all three priestess. I think what is happening in many jurisdictions, not only in South Africa, but also in other jurisdictions, is that the not sufficient attention is paid by government officials, be they the legal drafters, be it Parliament, or be it the implementers, the government departments, as well as the mining companies, as well as NGOs, of the global or international framework, the African framework, and the REC frameworks. And there are many, many rights and enforceable rights on the one hand. On the other hand, there are also obligations and commitments by our governments. So I think that is something that that I've really come to become very concerned about, because that is not in the knowledge domain of the various officials, etc. Then, secondly, specifically, Korir, thank you for your speech. I think that one of the key issues is about the recognition and incorporation of legitimate, and I want to stress the word legitimate, internal community governance structures. And that in many instances, that doesn't happen in South Africa, but in many other jurisdictions. And I think that is a key issue. You mentioned the issue that there are 4 or sometimes 6 representatives of the communities, but it doesn't even necessarily say that they are part of the internally recognized. And secondly, I think a key issue for all countries, but coming from your presentation, is the role of the government entity or structure responsible for regulating mineral extraction. And I think that in many instances they fail dismally. I'm not saying in Kenya, for monitoring the formulation of social labor plans or what the development program is, to ensure that there is sufficient and legitimate and inclusive community involvement. Also, not to ensure that it is properly implemented, it's not monitored, and very importantly, if they are not complied with by the mining company, that there's no accountability enforced by government and there are no consequence management. So those are some of the comments, not only for Kenya, and I think in general, that working on the book that you've mentioned a couple of times, Yvonne, I think you mentioned the book, and I think Anri also, I think that is basically a key issue.
I completely, appreciate what Nico is saying. In the Kenyan context, of course, our constitution recognizes that, for example, treaties that are ratified by Kenya are part of Kenyan law. So in a way, we are sort of a monist state in that regard, but there is a huge dissonance, nevertheless, between our compliance with international obligations, and what the law actually says. And so I think what you have said in that respect is extremely, extremely legitimate. The second issue around monitoring is a very, very interesting issue. It's something that Eleanor Ostrom flags up as being critical for resiliency, of common property regimes, where the issue of benefit sharing, at least from my perspective, lies. But I think even where I sort of laud, the oil and gas provisions on local content as being stronger on the monitoring side, when you look at the institutional side, the Energy and Regulatory Authority that is vested with the role of undertaking the monitoring, for example, has another 16 functions. So monitoring of local content plans is just one of the 16 functions, and probably the least attractive. And therefore, up until this time, for example, we have seen absolutely nothing that institution has done in relation to the monitoring of local content plans in relation to oil and gas, and that is an area where we actually have very clear legislative instructions about which institution should engage in that exercise. In relation to mining law, we don't even know who should undertake the monitoring exercise, so to speak. And so that just speaks to the gaps that exist within the area of realizing the objective of local content law, and whether in fact, like my sister says, whether in fact there is real deep commitment on the part of the state to ensure that locals benefit from resource extraction activities. Thank you very much, and I really look forward to continuing being part of the team and continuing to converse with all of us. Thank you.
One of your questions was, at what level will legal design thinking make the biggest contribution? And if I may make a suggestion as possibly to consider or to discard, of course, is that if you could develop a course in how this can be applied in South Africa and get that SARChI accredited, and then offer that course to the state law advisors, also to the DMRE policy and legal directorates, not only the legal directorate. Thirdly, to the National School of Government in Pretoria, and then one of the vehicles that you could use also to attract other interests, academics, students, practitioners, would be the UCT Law at Work, which is a very, very successful. So I think there's much to be done in this regard. And if you have it SARChI accredited, then you will attract government officials because they get benefits, time off, but also it is also for promotion and bonuses and things like that. And I think it's extremely important. So thank you for this. And I think this can help also to, as I said in my note, for the implementation part and really bringing self-sustainable benefits to the communities. Then finally, Yvonne, just a very brief comment. Thank you for what your, if I might say, your excellent overview of the way that Botswana has, by and large, managed to escape the resource curse, and probably the only country in Africa, South Africa definitely not. So I can say, so I'm very glad about the way that you put this forward. It's most unfortunate what has happened to the Masarwa, if I may use that term, in the central Kalahari. And I do hope that those things will change, because that is really a blemish on the very positive record of Botswana. But I've recently done some work on the and you refer to the Fraser Institute, but if we just compare, the Fraser Institute did not comment on Kenya. But in the latest report, the 2022 report, they said that the Botswana's investment attraction is 10th out of 62. South Africa, 57 of 62. So we're one of the least attractive for investment, and Botswana is second. And then very important, Botswana's investment attraction is number 10, my apologies. And the policy perception, and that is one where we are really lacking in South Africa, is number 2 in the world out of 67. So they've got a clear policy. That policy doesn't change every year or every 3 months or every 6 months or every utterance of a minister or a secretary general. The investment attraction is 10 out of 62, with South Africa being 57 out of 62. And interesting, the best practice mineral potential index is 22nd. So I think there's a lot to be said for South Africa and for other jurisdictions to this, what you have described, to popularize it. And I do hope in the book that you have referred to, that there will also be an opportunity to pick up those best practices and the best realities to develop a new implementable framework. But for all 3 speakers, my congratulations. I've really enjoyed this thoroughly. Take care and thank you so much.
Nic, thank you so much for the challenge of creating a course. I think that's a great idea. I'm getting direct messages here from people saying, oh, we really need to do this. It's an excellent idea. So the floor is open again.
Good afternoon, everyone. I just want to make a comment to Anri. In one of your points, you said that the legal design thinking is not a silver bullet. And I was really inspired by what Professor Nic said about creating a course, because yes, it is true that there is politics around the meaning of community and the definition of community, but politics are not set in stone and they can always be moved. And I think that's the value of a researcher, that's the value of an academic, is to move people with information. And I think it's a very important design. And I think of past academics and legal scholars who came up with concepts such as transformative constitutionalism, that was once just an idea, and now it is being used in the courts to transform society. So I really think this is it's an amazing idea, it's an amazing concept, and it really could be a silver bullet or one of many.
Thank you, Zandile. I'll say a bit on the course in a moment, but I think I like what you're saying about politics, and I think the same goes with that's probably why we're struggling with this, the definition of community. It's dynamic, right? And I think legal design thinking wants us to probably realize that, because we want to look at, if we want to look at we create the target audience, we've got a provision for communities, then the target audience should be the community. So we have to shift our minds, or the way in which we think about the law, to then sort of be adaptable or open to this dynamic nature. But I think the problem there, or the tension that we have there, is mining requires legal certainty and investment attraction. So I think there's that difficult tension between maintaining that while also saying, but yes, we truly are there to engage with the human at the other side of the law. So I think that's what I'm trying to get my head around, is if we really are going to create solutions, firstly, who are the target audience? And secondly, realizing the target audience is not set in stone. So I think that is a nice challenge to have. And then just about the course, yes, so I think, I mean, we've got the UCT Design School now, so I think there's a lot on design in different disciplines at this point. What I want to say is watch this space, there might be more coming.
I guess my question is, we are now in this period of mineral circularity and extracting minerals from hazardous waste like electronic waste. And this is a very interesting change in direction where we have this principle of extended producer responsibility, where producers of these products need to manage all of these different negative equities that you see coming from hazardous waste. If hazardous waste, when we consider it as hazardous, which it often be. So how do you see mineral circularity developing on the African continent? What are the potential pitfalls when you look at it from your kind of thesis perspective with hazardous waste concern? I mean, I suppose it comes to a lot of resource curse dynamics where we have a lot of this hazardous waste dumping that's happening, and the potential PR spin that could happen, I think, is that now this waste is valuable and we should be using it, and instead of seeing it as this hazard, because it's all kind of coming together. There's very few environmental policies that guide this kind of trade, and with the mineral compass in that, it just becomes wild terrain. So I would be really interested to hear your perspective on that.
I love these kinds of questions. They get me very excited. I think, first of all, what we would need to have, a model law. Yes, we are trying to protect our environment, look at local content, ownership, and so on. But we need to be careful to strike a harmonious approach. That's what I call it, between trade, environment. When in this era, we're talking of sustainable development. If we say we are signatory to WTO agreements, we are promoting free trade. Yes, it is nice and good that we encourage foreign direct investment and so on. But we just need to be careful not to be too protectionist. You see, like in the scenario of Botswana, they have Botswana, they have foreign companies there and so on. Once upon a time, there was a foreign company that went and they were exploiting, this wasn't diamond, it was it copper or nickel, somewhere in the Selebe-Pikwe area. And they weren't adhering to what the laws were saying. They were causing a lot of pollution and all those things. And as usual, the local populace was really at the mercy of this foreign company. What the government then did was they canceled the permit and threw the foreign company out. That is them. I think that, yes, you encourage, foreign direct investments. Yes, we want free trade. Yes, but we also want the interest of this ownership thing. We want a law that will not just stipulate that let's do this and that, but protect environment, make sure that the local populace also benefits. Have all your environmental principle, precautionary principle. If you are not sure of the impact of your activity, don't even engage in it. Human rights to a decent environment, all those beautiful environmental law principles. Local level populace, local level governance, you have the interest of the locals, they are being reflected through what their leaders are saying, so you have your free trade principles, you also have your environmental law principles, you are granting incentives. I think sometimes we just bash the foreign companies also. Why don't we try and, adopt this carrots and sticks approach? Yes. We talked about extended producer responsibility. It is very important. But sometimes too, from the, I did my thing in my thesis in an environmental law institute. But I started also by talking about WTO and free trade, because free trade is good for us. It's just the extent to which we implement free trade. There's something called sustainable free trade, sustainable mining, and so on. So we don't want waste to be mining waste to be dumped rather haphazardly or recklessly, you see, without due consideration to the interest of our locals and so on. So we need penalties in our law, as is done in the Botswana scenario. But we also need incentives. We are not just there as watchdogs, just to bash people. I don't think that's even a good approach. When the Botswana and them, they do good things, let's highlight it. Let's form a partnership between trade and environment. Then we'll have the interest of the locals being promoted and so on. So I think at the end of the day, that is what the model law should talk about. And then we have extended producer responsibility. We know that from our mining activities, if we extract something negative, well, we are going to be held accountable. But also, if we do something that is good, they are going to showcase us, whether on CNN, in the law books, wherever. I mean, it's exciting and it's a good thing, you know. The Botswana and them now, they're enjoying when we talk about good things that they've done. It even motivates them to do more, you see. So I think at the end of the day, it's just that harmonious balance that we adopt between trade and environment, you know, as the WTO and AU and SADC and the rest, they say we should do. We should try and implement that at national level, at respective local levels and so on, and just balance things so that our local communities will just enjoy peace and nothing but that.
Thank you, Yvonne. There's also a question from Wandile, and it's about what best practices could be fashioned around local communities and community beneficiary design. And I see Anri is also interested in that conversation.
Yeah, so I was thinking about asking you this, Yvonne, as well as if we look at Botswana, can we pick up some characteristics of their legislative system or their policies or something like that, that we can see those are the indicators of success? And maybe that's something going forward when you do your chapter on Botswana and things like that, that we see if we can distract some of those principles to see, but what is it that we are looking for? Because I think my question at the end of the day is, what is the measure or the indicator of a successful local content law? And that's probably why it's so difficult to address, because it's about communities, but it's not just about communities. It's about more than that. So maybe I'm going to leave our conversation with that open-ended question. The whole purpose of today was to start a conversation on this and hopefully to follow up with other conversations or publications. And as Anri said, in drafting some kind of a manifesto. I really want to thank each of you for joining us today and for sticking it out until the last bit, especially to you, Yvonne, for your wonderful contribution today. Thank you so much. Korir as well. I think it was very insightful to hear the analysis from a more theoretical perspective by comparing it with the Ostrom principles. I'm looking forward to conversations that we can have. Thank you to all our MLiAns that also supported us today.
Thank you, Anri. We've considered legal design thinking as a tool, channeled Ostrom in search of responsive design thinking, and looked at perspectives from Botswana. Let's turn now to Professor Bastida, whose presentation offers a different angle.
Thank you very much for the invitation to join you in this conversation on this very important, exciting topic. I like the challenge to think about the role of law and institutions in local content to promote better outcomes, and the idea of legal design, the idea of how we can use legal design to promote better outcomes. My intervention and my entry point in this conversation is different than from the other participants. My presentation is called Designing Law and Institutions to Promote Local Productive Capacities. And the starting point of my brief presentation is pointing at the local governance gaps of institutions that were designed particularly for low middle-income countries with intervention of international organizations, particularly at the end of the 80s and 90s in Africa, or for Africa and Latin America. And that model was typically was typically a model of territorial management that saw mining or conceived mining as a predominant activity in a territory. And it was designed to facilitate access to territories for investment and to connect those territories to global supply chains, to the global economy. So in that, in the design of that model, there was not intentional design for including local actors, local ecosystems, local units of government. So that has been, we know so much, there is so much literature on different aspects of the failure and the gaps, the structural gaps of this model. And so that is my entry point to the question of legal design. So I see local governance gaps as deficits of design. Deficits of design, if we look at them not from the point of view of the global economy, but from the point of view of local outcomes, sustainability, justice outcomes, and from the point of view of local stakeholders, local communities, local economies, and ecosystems. So I would say, and so that, as I said in the slides, local regulatory and governance gaps for managing the sector are rooted in the deficits, in the very same deficits of this very same design of the legal and institutional regimes in the sector, for the sector, that, as we know, there has been so much research about them. So there has been much research that looking at the enclave model of these projects. So we know that mining projects can operate as enclaves without forging linkages with local communities and local economies. This happens because mining can inject large amounts of capital in regions that without economic strengths, without pre-existent economic strengths. And so they can, at the same time, they can potentially establish the grounds for more diversified economies, but this does not happen automatically. This needs to be established, supported, and created. In a way, so that model, that is a model of territorial management as well, that assumed that the lack of potential and the lack of capacities at local level to catalyze broad-based development at that local scale. So, as I say in my next slide, so we know there has been an evolution of understanding, at least at the level of understanding, from enclaves, that is an understanding on a turn from enclaves to multi-level, holistic and integrated governance. I think the report by International Resource Panel that was released in 2020 after very, very thorough review and research. So look at place the spotlight on the need of holistic and multi-level approaches to governance that also, of course, also incorporate the local scale, the local level. And so there is an understanding of moving away from an extractivist model to a transformational model, and that promotes sustainability across scales, and starting with the local scale, of course. There is also a very interesting report, a vision that the IADB formulated in 2020, or at least published in that year, where there is also a vision for turning away from and breaking away from a model based on comparative natural advantages to one that adds value and adds knowledge to natural resources and promotes development through collaboration to produce knowledge and technology, technological innovation, environmental resilience, and more equitable wealth distribution at territorial and national levels. The territories, the places, the location, that local scale that was absent in policy debates, in instruments for the sector, it has emerged. Yes, of course, this is not new. So now there is much debate in the context of critical minerals, of the energy transition minerals, of the demand for minerals for the decarbonization of the economies. But these issues emerge in mostly in the late 2000s, and a very important instrument was the African Mining Vision, that again placed a spotlight on the question of linkages, on the potential of the mining sector to play a transformational role if it could build linkages with other sectors of the economy, linkages that occur both forward, backward, and across sideways, and included the question of local content, included actions for local content. So in my next slide, I would like to turn to the main aspect of my presentation and my contribution on the question of design, of legal design, and my approach to the question of legal design, that I think that there is a need of designing a law and institutions to bridge those local governance gaps, to provide a supportive environment for local productive activities to occur. So I don't not focus as much as requirements on local content, on legislative requirements on local content, but rather on the institutional environment that needs to be in place to support local productive activities. So that is a different approach in terms of legal design, legal policy and institutional design. And I think here we need to borrow conceptual frameworks from other disciplines. And here, I think, as I said at the beginning of the presentation, there has been traditionally an implicit model of territorial development that didn't see much in terms of the ability of local governments to play a role in connection to the sector, to the mining sector. So there has been a turn in the view of the role of local units of government, more generally beyond the mining sector, but in terms of the role that municipalities, local councils can play in terms of the abilities, instruments, and the governance frameworks that they can use to improve the quality of life of local populations. That is the scope of their work, the ambit, the scope, the territorial scope of their work. So I referred before at the turn as well in the mining sector of instruments, in the visioning of about the way the mining sector needs to work with. And we see the emphasis is much on collaboration and multi-level and holistic approaches to policy. So that means basically that the local scale needs to be coordinated, to work with in coordination with with other administrative scales of government to support local outcomes. So the promotion of sustainable processes of local development need to be in coordination with other administrative units and other sectors and civil society. Of course, that it is easier said than done, because there is often deficits of articulation, deficits of instruments to articulate common action. And here again, the concept of legal design is important. So how we design in legal terms the instruments to work together, to work in collaboration with other scales, with other sectors, with civil society, government, with civil society, local communities. Yes. So all this means that what all this means is the centrality of the territorial scale in legal design to promote local productive activities. So again, this needs design. This needs design, policy, institutional, legal design, and the centrality of the territorial scale, as I said before, needs coordination, coordinating multi-level actions through nested institutions. So our previous speaker has talked about Ostrom and what we can learn from the frameworks of governance, adaptive governance, and it is in essence that framework we need to use to work together in collaboration across scales, and how other scales of administration and also different actors in an activity as global as mining is. So how different actors can support the local scale of work. So I think that it is a different way of designing policy and institutions for local development. Another important point is another turn in the way that public administration works at the local level is the turn to work towards outcomes that are monitored, follow up through metrics as goals, performance indicators, and standards. So the local scale is the appropriate scale for, of course, localizing the Sustainable Development Goals and establishing specific metrics to follow and methodologies to follow up on those on the achievement and progress towards those goals. So so that is as it flows from the presentation. So designing law and institutions for local productive activities means, in essence, to establish the centrality of the local scale, to establish institutions, and as we said in the next slide, establish institutions that it could be local agencies, local councils, councils that work with other levels of government, and also work establish certain methodologies and planning instruments like strategic assessments and territorial planning, and also strengthening, establishing programs for strengthening local participation in citizen participation in local affairs. So the literature sees the literature not as much, I would say, in the mining sector, because this is a topic that has not been explored in depth. In my own work, I have explored it briefly in some research I did a few years ago, and then in the context of some policy outputs, we prepare with colleagues in 2021, and particularly a group of colleagues at the University of San Juan in Argentina with much expertise on territorial development, prepare a series of outputs reflecting on the role of municipalities in the mining sector. And so you will see that many of my references rely on this. But to sum up and to finish my presentation, I hope that it provides food for thought and for this conversation, and that hopefully for more collaboration. Collaboration, I think, is not only collaboration, does not only refer to collaboration at government level, but with other actors. And I think academia has a very important role to play in producing outputs, in producing, in establishing, in catalyzing, in convening this type of conversations, in opening spaces for debate and for reflection, and also for bringing different actors and difficult conversations in these controversial topics together. So to finish up my presentation, to round up, so the role, what is the role of local units of government, as Valentina Soria, the author of this report, says. So she says that the central role, she sees a central role of local units of government for managing, facilitating, mediating, and catalyzing the various demands and proposals of various actors towards a common vision that is articulated at territorial level. And I would add also with the support and the articulation with other actors. So to steer actions from other actors, to support the achievement, the meeting of those goals. All that needs design. I say that it is development, local development by design. It needs design through law, policy, and governance, and also designing programs to support local capabilities and strengthening local capabilities, both of staff, of government staff, and also of civil society, abilities to participate, engage, and to empower them. So I hope that this has provided food for thought, and it has been a pleasure to join.